What?
Each one's at least an hour long.
Practically. All right. So, reading Real Covenants. Reading it here. I'm sorry, restrictive covenants. The covenant is a written promise to do or not do something related to land, for example, to maintain a fence or to not build a multifamily dwelling. It's unlike an easement because it is not the grant of property interest. Instead, it is a contractual limitation or promise regarding land. Real covenants are normally found in deeds, and where certain requirements are met, they run with the land at law, which means that subsequent owners may enforce or be burdened by the covenants. Negative and affirmative covenants are your types. They're defined. Covenants can be negative. These are known as restricted covenants. The restrictive covenant is a promise to refrain from doing something related to land. What are some examples of restricted covenants? Affirmative covenants. Covenants can be affirmative. The affirmative covenant is a promise to do something related to land. What are some examples? Take this. Covenant versus equitable servitude. On the exam, the same set of facts could seem to give rise to either covenant or equitable servitude. How would you know which analysis applies? What that means is that if the plaintiff wants money damages, you must construe the promise as a covenant. If the plaintiff wants an injunction, you must construe the promise as an equitable servitude. Running with the land. If in the covenant parlance, one tract is burdened by the promise and the other is benefited. Our key question in this area is figuring out when the covenant will run with the land. In other words, when is the covenant capable of binding successors? When will the burden and or benefit run to the successors? There's a picture in Hypo 9, and it is demonstrating what is horizontal privity and vertical privity. So horizontal privity occurs between the original parties, the burdened and the benefited, aka the servient and the dominant. And then their successors, among their successors, each one, the burdened and the benefited has a successor. There is vertical privity between those two parties and sequential successor parties. So I'm not going to read the hypo. We're skipping hypos in the CMR. Section 9.1.4, requirements for burden to run. If the following requirements are met, any successor in interest to the burden estate will be bound by the covenant as if they themselves had expressly agreed to it. For the requirements for the burden of a covenant to run, remember within. And so that's the mnemonic for a burden to run. And I'm just looking for within, where the W is the writing, I do believe. Let's actually go to the next page. Yeah, writing intent, touch and concern, horizontal and vertical privity, and notice. So this is like everything. Real covenant burden. Requires the writing, which is the W and within, intent, touch and concern, that's your TC, horizontal privity and vertical privity, and notice. So, moving on. Okay, so each one of those elements is defined. Writing is clearly a original promise between the original parties, which has been in writing. Intent is the original covenanting parties must have intended that the covenant would run, meaning they intended that successors to the originally promising parties would be bound by the covenant. This intent may be inferred from circumstances surrounding the creation of the covenant, but it is usually found in the language of the covenant conveyance itself. For example, A promises on behalf of herself, her successors, and assigns ... the rest of the covenant, the rest of the promise, and the courts are generous in finding requisite intent. Touch and concern. A promise must affect the parties' legal relations as landowners and not simply as members of the community at large. Restrictive covenants touch and concern the land if they restrict your burdened parcel in her use of that parcel of the land. Affirmative covenants touch and concern the land if they require the holder of the servient estate to do something that increases her obligations in connection with the land. Covenants to pay money to be used in connection with the land, such as the homeowners association fees and covenants, do not compete, do touch and concern the land, or covenants to not to compete. So those are some examples of touch and concern. You've got your homeowners association fees, do not compete. Horizontal and vertical privity, both are required for the burden to run. Horizontal privity refers to the nexus between original promising parties. I like the word covenantors. That requires they be in succession of estate, meaning that they were in a grantor-grantee or landlord-tenant or mortgagee relationship when the covenant was created. In other words, at the time the promisor entered into the covenant with the promisee, the two must have shared some interest in the land independent of the covenant. Horizontal privity is difficult to establish, and absence is the reason why many burdens do not run. Vertical privity refers to the nexus between the successor and interest. And I'm just going to write here, it requires a relationship. I don't really know that. Like shared interest in land. The vertical privity, again, is between the successor and interest in the original covenanting party. It simply requires some non-hostile nexus, such as covenant, devise, or descent. The only time vertical covenant, devise, or descent. What else? The only time vertical privity will be absent is when the successor acquired her interest through adverse possession. Notice. The successor must have had notice of the promise when she took. Why? Because under modern recording acts, to be bound by a covenant, the subsequent purchaser for value must have had actual inquiry or record notice of the covenant at the time of the purchase. Requirements for the benefit to run. What you're asking here is, does the successor have standing to enforce the covenant? If the requirements are met, the promisee be successor in interest. Next page. May enforce the covenant for the benefit of the covenant to run. Remember, WITV, because horizontal privity is not required. So what's not required of the list I just gave? For some reason, notice isn't required either, which is insane. And so writing intent, touch and concern, and vertical privity is required. So we define each element again. Writing, the original promisee between A and B must have been in writing. Intent, the original covenanting parties A and B must have intended that the benefit would run, meaning they intended that successors in interest of the promise E would be able to enforce the covenant. Touch and concern. The benefit of the covenant touches and concerns the land if the promise performance benefits a promisee and her successors in the use and enjoyment of the benefited land. In other words, the promise must affect the parties as landowners. And vertical privity, there must be a non-hostile nexus between the original promisee and the successor in interest. Specific situations involving real covenants, generally promises to pay money to be used in connection with the land, for example, homeowners association fees. Good boy. That's enough. So next page. And covenants not to compete run with the land. Racially restricted covenants are unenforceable. Remedy damages. A breach of a real covenant generally is remedied by an award for money damages, collectible from the defendant's general assets. If an injunction is sought, the promise may be enforced as an equitable servitude, which we're going to talk about in this module, actually, in just a second. So the termination, as with other non-possessory interests, a covenant may be terminated by a written release, the merger of the benefited and burdened estates, and the condemnation of the burdened property. Equitable servitudes. An equitable servitude is a promise in equity that equity will enforce against successors. Of the burdened land, regardless of whether it runs with the land at law, unless the successor is a bona fide purchaser, meaning the subsequent purchaser for value without notice of the covenant. The equitable servitude is accompanied by which form of release? Creation. So basically, that's a way of determining that it's not a real covenant, right? An equitable servitude is enforceable on equity. That's like the only difference. Creation. Generally, as a real covenant, equitable servitudes are created by promises contained in a writing that satisfies the statute of frauds. To create an equitable servitude that will bind successors, remember witness. So the writing, the intent, the touch and concern, notice, and yes is for equitable servitudes. Interesting. Writing, generally but not always, the original promisor has been writing. A common scheme doctrine discussed below is an exception to this requirement. Intent, the original parties intended that the promise would be enforceable by and against successors. Touch and concern, the promise affects the parties as landowners. Notice, subsequent purchasers of land burdened by the covenant had actual inquiry or record notice of the covenant when they acquired the land. Note that this rule is part of the law of equitable servitudes and exists apart from the recording acts. So notice is required to bind the subsequent purchaser regardless of whether they seek the protection of a recording act. On the exam, though, a recording act will usually be involved. Note that in most states, successors of burdened land who are not purchasers, such as donees, are bound by the covenant whether or not they had notice. In the implied equitable servitude, the general or common scheme doctrine. This issue will likely be on the exam. You can think of it as an exception to the general requirement that the original promise be in writing. And here's a checklist on page 61, and it shows what's required for benefits and burdens to run on covenants as opposed to equitable servitudes. I have seen this table a lot. It's going to be hard to read aloud, so just revisit it another time. Under the common scheme doctrine, actually, let me give the mnemonic. So for the benefit to run on a real covenant, the mnemonic was more abbreviated than within. It was just like writing, intent, touch and concern, and vertical privity. For the burden to run, you need everything: writing, intent, notice, touch and concern, horizontal privity, and vertical privity. For equitable servitudes, the benefit can run with intent and touch and concern only, and the burden runs with intent, notice, and touch and concern. Under the common scheme doctrine, the court will imply a reciprocal negative servitude to hold the unrestricted lot holder to the promise. Reciprocal negative servitude means an implied equitable servitude. Thus, if a developer subdivides land and some deeds contain restricted covenants while others do not, the restricted covenants will be binding on all parcels, provided there was a common scheme of development and notice of covenants. Elements of the common scheme doctrine. The two elements of the general or common scheme doctrine: when the sales began, Subdivider A, the common scheme of residential development, which included the defendant's lot. The scheme may be evidenced by a recorded plat, a general pattern of restrictions, and oral representation to early buyers. And the defendant lot holder B had notice of the promise contained in those prior deeds when it took notice. For the three forms of notice, remember AIR, actual notice, inquiry notice, and record notice, meaning the defendant had literal knowledge of the promises contained in the prior deeds. Inquiry notice, meaning the neighborhood seems to conform to a common restriction, it's the lay of the land. And record notice, meaning the form on notice sometimes imputed to buyers and on the basis of publicly recorded documents, so there's a prior deed with the covenants and grantee's chain of title. Equitable defense is to enforcement. A court will not enforce an equitable servitude if the neighborhood conditions have changed so significantly that enforcement would be inequitable. The changed circumstances alleged by the party seeking release from the terms of the equitable servitude must be so pervasive that the entire area or subdivision has changed. That what's never good enough here is piecemeal change or mere pockets of limited change. I learned that recently. Get an answer wrong. The person seeking enforcement is violating a similar restriction of his own land, unclean hands. So again, these are equitable defenses. Change circumstance, unclean hands, acquiesce, estoppel, and laches. So a benefit party acquiesced in violation of the servitude by a burdened party. The benefited party acted in such a way that a reasonable person would believe the covenant was abandoned or waived, estoppel, or the benefited party fails to bring suit against the violator within a reasonable time, laches. Termination, like other non-possessory interests, an equitable servitude may be extinguished by written release from the benefit holders, merger of the benefited and burdened estates, or condemnation of the burdened property. What are you doing? Distinguishing characteristics of real covenants and equitable servitudes. Creation, real covenants. A writing is always required. Equitable servitudes, a writing is usually required but may arise by implication from a common scheme or development of a residential subdivision. Running of the burden. Horizontal privity, shared interest in land apart from the covenant by original covenanting parties, example, mortgagor, mortgagee, landlord-tenant, or vertical privity, successors holds entire interest held by the covenanting party is required. No privity is required in equitable servitudes. Running a benefit, vertical privity is required in real covenants, but no privity is required in equitable servitudes. And for remedy, generally damages are available, but for equitable servitudes, generally an injunction is available. Might be the only one available. This next table on page 64 gives the definitions and example of writing and termination. So I'm just going to read the definition. Writing. Let's just say for an easement, a writing is generally required except when it's less than 1 year or created by implication, created by necessity, or created by prescription. A license, no writing is required. Oral easement is an invalid oral easement defaults to a license. For a profit, a writing is required. For a real covenant equitable servitude, a writing is required with the exception of what we were saying is the implied common scheme of development of residential subdivision in an equitable servitude only, not in the real covenant. And for termination, no, for the definition, what's an easement? It's a grant of interest in land that allows someone to use another's land. License is permission to go onto another's land. A profit is the right to take resources from another's land. And real covenant equitable servitude is a promise to do or not to do something on the land. You get examples. I just read writing. To terminate an easement, I remember it being end cramp, which is estoppel, necessity, distraction, conditions, stated conditions being met, release, abandonment, merger, and prescription. For the license to be terminated, it's usually revocable at will, but maybe irrevocable if coupled with an interest, or if the licensor has a stop by the licensee's expenditures of money and labor. Profit is the same as an easement. and cramp again. And then real covenant, equitable servitude. You have release, merger, condemnation, and also for equitable defenses, it may apply to enforcement of servitude. Next page is adverse possession. This is module 10. And the basic concept here is that possession of a statutory orally prescribed period of time can, if certain elements are met, ripen into the title of real property. Title by adverse possession results from operation of the statute of limitations for ejectment. If an owner does not, within the statutory period, take action to eject a possessor who claims adversely to the owner, title vests in the possessor. The elements, again, are the same as prescription here, giving COA, continuous, open and notorious, actual and exclusive, and hostile. Continuous means an adverse claimant's possession must be continuous throughout the statutory period. Intermittent periods of occupancy are not sufficient. However, constant use by a claimant is not required as long as possession is of a type that a usual owner would make. Also, there need not be continuous possession by the same person. An adverse possessor can tack her own possession onto the periods of adverse possession of predecessors. Open and notorious possession. The adverse possessor's occupation must be sufficiently apparent to put the true owner on notice that a trespass is occurring. Actual and exclusive is that an adverse possessor will gain title only on the land if they actually occupy. In some cases, however, actual possession of an entire parcel claimed is not necessary, and an adverse possessor enters under color of title, meaning an invalid deed. She is deemed to be in constructive possession of all the land that the deed describes, as long as she is in actual possession of a reasonable portion of the land. And exclusive possession means that the possessor is not sharing with the true owner or the public. Two or more people acting together could succeed in obtaining title by adverse possession. They would take title as tenants in common. Hostile means, or the requirement is satisfied if the possessor enters without the owner's permission and the state of mind of the adverse possessor is irrelevant. It doesn't matter whether the possessor actually thought that they were on their own land or knew that they were encroaching on another's land. When possession starts permissively, for example, by lease, possession does not become adverse until the possessor makes clear to the true owner the fact that they are claiming hostility. Co-owners requires an ouster to create hostility. So possession by one co-tenant is not adverse to the other. Co-tenants voluntarily out of possession because each co-tenant has the right to possession of all the property. A co-tenant must oust others or make a explicit declaration that they're claiming exclusive dominion to create adverse possession. If the grantor stays in possession, permission is presumed. Where a grantor stays in possession of land after they conveyance, they're presumed to be there with permission of the grantee. Likewise, the tenant remains in possession after the expiration of the lease. They're presumed to have permission from the landlord. Claim of right. A possessor enters under claim of right when they reasonably believe that the property belongs to them, usually because they have an invalid deed. An invalid deed does not give the possessor permission to be on the land. When someone assumes possession with what mistakenly believe is valid title, the possession is hostile and adverse. Most states use claim of right instead of or interchangeably with hostile. Running of statutes. The statute of limitations begins to run when the true owner can first bring suit. Filing a suit will not stop the period from running. However, the suit must be pursued to judgment. Payment of property taxes generally is not required. Most states do not require the adverse possessor to pay taxes on the property, but consider such payment good evidence of a claim of right. Now, tacking and tolling will come next. Tacking. One adverse possessor may tack onto his time with the land his predecessor's time, so long as there is privity between the possessors. Privity is satisfied by any non-hostile nexus, such as contract, deed, or will. By contrast, privity is absent when the possessor acquires possession by ousting his predecessor in possession. That's not privity. Disabilities. The statute of limitations will not run against the true owner who is afflicted by a disability at the inception of the adverse possession, meaning that when the cause of action first accrued, only the disability of the owner existing at the time the cause of action arose is considered. What are some common disabilities? Funny they don't answer that question. But you have infancy, insanity, pretty sure being confined, and Those are the ones that come to mind. Adverse possession and future interests. The statute of limitations does not run against the holder of a future interest until the interest becomes possessory. Effective covenants and true owner's deed. If an adverse possessor uses the land in violation of restrictive covenant in the owner's deed for the statute of limitations period, they take free of the restriction. If, however, the possessor's use complies with such a covenant, they take title subject to the restriction. Last section, land that cannot be adversely possessed, title to government-owned land and land registered under the Torrens system in place in a small minority of states, whereby title is established with the governmental authority that issues title certificates to owners cannot be acquired by adverse possession. So now we're on page 70, module 11, conveyancing the purchase and sale of real estate. Every conveyance of real estate consists of a two-step process. Step 1, the land contract, which conveys equitable title. The land contract endures until step 2. Step 2 is the closing, where the deed passes legal title and becomes our operative document. Keeping the two steps separate, the closing date is generally set in the contract. The buyer and seller typically meet on that date at the title insurer's office or similar place to exchange the purchase price for the deed. It's important to keep the two steps in the real estate sale separate in your mind before the closing. Contract rules apply after closing. We're strictly in the realm of real property law. It's a good idea to associate certain issues with before closing and others after closing. Common issues before closing. If there are going to be problems with the sale of land, they generally arise during the period between the signing of the contract and the closure date. This is sometimes called the escrow period. During this time, a number of things could cause one of the parties to change of heart and try to back out of the contract. The buyer might learn of the title defects or termites or bad plumbing and wish to rescind the contract. The seller may discover that they can get a better price and want to rescind the contract. What if the property is damaged or destroyed during this period? Who will bear the cost of the loss? Caveat emptor places that on the buyer. But if the seller has insurance, the seller has to rebate the buyer. So they can't just take the insurance money and the purchase price in full. It would be inequitable. So common issues after closing. Problems with the buyer and seller are less common after closing. These issues are most likely to arise when there's title problems or encumbrances are discovered after closing. For example, what if it turns out that the seller sold the property to multiple buyers? What if after the closing the buyer discovers that the neighbor has an easement over the property or a judgment creditor has a lien on the property? And they do have recourse against the seller if the type of deed covenanted, future covenants, which might be of multiple types. There's present covenants and future covenants. After closing, the present covenants go away. But the future covenants remain. So here we go. The present covenants are covenant of cession, covenant of right to convey, covenant against encumbrances, covenant. Now the future ones are covenant for quiet enjoyment, covenant of warranty, covenant of further assurances. So that actually wasn't a module at all. Now we're in the module of land sale contracts. That was just like an introductory section. Conveyancing starts with the real estate contract. This contract is the same as any other in terms of what is required to make it enforceable. As always, we need an offer, an acceptance, and consideration. A contract must comply with the statute of frauds, and there must not be any defenses to enforcement. Statute of frauds applicable. Because of the real estate contract involves an interest in land, the statute of frauds requires a writing signed by the party against whom enforcement is sought. In other words, signed by the party currently being sued. In addition to that signature, to satisfy the statute, the writing must identify the parties, describe the property, and include the price, the consideration, or other means of determining the price, such as the fair market value as determined by the appraisal. So, land sale contract. I'm guessing this came before the deed section. Sure. All right, so we don't have the requirements written here. Please try to remember them. What is required? Identification of the parties. These are so minimal. A description of the property. And a price or a means of determining price. These terms must be definite enough for a court to enforce a contract, so a court can tell from the documents who the parties were, which parcel is being conveyed, and what consideration is being supplied the statute is satisfied. Inaccurate description of land. Sometimes the land description in the contract will overstate or understate the amount of land being transferred. On the bar exam, you're more likely to see a contract that overstates the size of the parcel. Exception to statute of frauds, the doctrine of part performance. I have it here, but it doesn't say anything. So what happens if there's no writing or the writing falls short of the requirements? Suppose, for example, that while chatting at the local diner, Kendall and Roman orally agree that Roman will buy Kendall's farm for $500,000. As so often happens on the bar exam, before closing the seller, Kendall meets a tragic and premature end. Kendall's estate decides that Kendall made a bad bargain and refuses to close, citing the statute of frauds. Anytime you see an oral contract for a sale of land on your exam, bells should go off alerting you to a statute of frauds issue. Roman, the buyer, has only one hope, the one exception to the statute of frauds in the land sale contract, the doctrine of part performance. Part performance is an equitable doctrine allowing the buyer to enforce an oral real estate contract by specific performance if the so it's enforceable by strict or specific performance only when the oral contract terms are both clear and certain, and 2, acts of partial performance clearly prove the existence of a contract. And so part performance is 2 out of 3 of the following: possession, paying the purchase price, or making substantial improvements. And I'm just going to leave it at that. There's all these other words here. Actually, the second requirement is usually satisfied if the buyer can prove 2 of the following 3 actions. Buyer is taking possession of the property. Buyer has paid the purchase price of a significant portion of the purchase price, or they have made substantial improvements to the premises. And so under possession, suppose the buyer moves into the farmhouse but hasn't yet paid the purchase price. The buyer will say, clearly I bought this. I am in the house. My stuff is here. I sleep here every night. Does this prove a sale contract? No, not on its own. Think of the tenant. The tenant occupies the land. That doesn't mean they own it. The evidence of the parties entered into contract must be unequivocal. There must be any other plausible explanation for the action. So possession is good evidence, but on its own, it's not enough. Purchase price. What if the buyer says, I gave the seller $200,000. That's a lot of money, and it happens to be about how much the house is worth. That's a great evidence, but by itself, it doesn't unequivocally prove the parties had a contract to sell the property. The money may be unrelated to the property. Maybe the buyer is paying off a gambling debt or loaning money to the seller. Improvements. Most people don't go around fixing houses they don't own. A lot of times people improve houses right after they buy them. They build a new porch on the house, install a swimming pool in the backyard, pave the driveway, something like that. Usually tenants, thank you. Zoom Butler. Yeah, thank you for being my Zoom Butler. Merry Christmas.
Siri, let 99 Jackson know that every employee needs to be
slap
eradicated and replaced by new interims by the end of the day.
You're all on permanent time off.
Yeah. They're just so bad. I'm sorry.
All right, we're gonna move on next page. Doctrine of equitable conversion. Once a contract is signed, equity regards the buyer as the owner of the real property. The contract conveys equitable title to the buyer, but at closing, legal title is conveyed to the buyer. So the right of possession rests with the party who holds legal title. Thus, the seller is entitled to possession until closing. And that's how the doctrine works. As it relates to the risk of loss, that means that the buyer can insure against a risk of loss such as destruction, which can happen between contract and closing. And I already explained how that works. Passage of title on death. Life expectancy for the parties on the bar exam. Okay, it's short. Haha. The deceased buyer's interest passes as real property to their estate. The deceased seller's interest, the right to the purchase price, passes to their estate as personal property. The contract remains enforceable, with the deceased party's estate taking the decedent's place in the transaction. Why? Because according to the doctrine of equitable conversion, once the contract is signed, equity regards the buyer as the owner of the real property. Two promises implied in every land sale contract. One, is that the seller will provide marketable title. Every contract contains an implied covenant that the seller will provide marketable title at closing. Marketable title is a title reasonably free from doubt and the threat of litigation. The common defects that render title unmarketable are defects in record chain of title, most often adverse possession, encumbrances, mortgage liens, easements, restrictive covenants, and zoning violations. Defects in the record chain of title, including adverse possession and encumbrances, zoning, yada yada. Warranties for fitness, time of performance. Just looking at how many pages. Okay, I don't have much pages left. Just to get to page 81, which talks about title insurance. A title insurance policy ensures that good record title of the property exists as of the policy's date, and promises to defend the record title if litigated. The owner's policy protects only the person who owns the policy, regardless, usually either the owner or the property or the mortgage lender, and does not run with the land of the subsequent purchasers. A lender's policy follows any assignment of the mortgage loan. So now I have to just get to page 80, which is remedies. We need to get through time of performance and tender of performance on page 79. And warranties on page 78. We're talking about also, what are they called? Misstatements. So where we were was defects of record chain of title, the types, and giving a definition of the types at page 76. So we only have like 9. We have like 4 pages left. Adverse possession. If even a portion of the title rests on adverse possession, is unmarketable. For title to be marketable, the seller must be able to provide what kind of title? Marketable title. Unless a suit has been brought to quiet title acquired by adverse possession does not appear in the record. Encumbrances. Generally, mortgages, liens, restrictive covenants, easements, options to purchase, and significant encroachments and render the title unmarketable unless the buyer has waived them. If an encroachment is very slight, as a matter of inches, and doesn't inconvenience the owner of the encroached on parcel, the encroachment won't render the title unmarketable. But an encroachment of a foot or more likely will. An easement that is beneficial, visible, and known to the buyer does not impair the marketability of title. Backwards. Page 77, zoning violations. Zoning restrictions do not affect marketability, but an existing violation of a zoning ordinance does render the title unmarketable. Future interest held by unborn or unascertained parties. When a holder of a future interest is unborn or unascertained, it is impossible to convey marketable title. Courts will not appoint a guardian ad litem to represent the unborn or unascertained parties for the purposes of conveying lands. And Part B, when title must be marketable on the day of closing. The seller has up until the time to clear up whatever defect is making the title unmarketable. In an installment land contract, the seller need not provide marketable title until the buyer has made his last payment. Remedy, if title not marketable. The buyer must notify the seller the title is unmarketable and give the seller reasonable time to cure the defects. If the seller fails to cure the defects, the buyer's remedies include rescission, damages, specific performance with abatement, and a quiet title suit. But if closing occurs, the title or the contract and deed merge, and the seller's liability on the implied contractual covenant ends. Next page. The seller will not make false statements of material fact. The second implied promise is the seller will not make any false statements of material fact. The seller may be liable to the purchaser after the closing for defects such as a leaky roof, flooding basement, termite infestation, if they knowingly made a false statement of material fact that the buyer relied on, actively concealed a defect, for example, wallpapered over water damage, or failed to disclose known defects in the property. A failure to disclose creates liability when the seller knows or had reason to know of the defect. The seller realized that the buyer was unlikely to discover the defect, so it's latent, and the defect must be serious enough that the buyer would probably reconsider his purchase. Factors increasing the likelihood that the liability will be imposed in these cases include whether the property is a personal residence, whether the defect is dangerous, and whether the seller created the defect or made a failed attempt to repair it. Disclaimers of liability. Can a seller avoid liability for fraud or failure to disclose by including in the contract a general disclaimer of liability, such as a property is sold as is or with all faults? If the disclaimer identifies specific types of defects, for example, seller is not liable for any defects in the roof, it will likely be upheld. No implied warranties of fitness or habitability. The land contract contains no implied warranties of fitness or habitability. Caveat emptor is the common law norm, and caveat emptor means let the buyer beware, which that means that they had to come and inspect the property. Exception, new home construction. Most courts recognize a warranty of fitness or quality in the sale of a new home by a builder. Negligence of builder. A person may sue a builder for negligence in performing a building contract. Some courts permit the ultimate buyer to sue the builder despite lack of privity. Time of performance, tenure of performance. 11.5, time of performance. Courts presume that time is not of the essence in real estate contracts, thus the closing date isn't absolutely binding, and the party late in tendering their own performance can still enforce the contract if they tender within a reasonable time, for example, 2 months after the closing date. When presumptions are overcome, time is of the essence if 1, the contract so states, 2, circumstances indicated the party's intent, and 3, one party gives the other notice that time is of the essence. Liability. If time is of the essence, a party who fails to tender performance on the closing date is in breach and may not enforce the contract. Even if time is not of the essence, a party who is late in tendering performance is liable for incidental losses. Tender of performance. A buyer's obligation to pay and the seller's obligation to convey are concurrent conditions, so neither party is in breach until the other tenders performance, even if the closing date passes. If neither party tenders performance, the closing date is extended until one of them does so. When parties tender excused, a party is excused from performing if the other party has repudiated the contract or it is impossible for the other party to perform, such as when unmarketable title cannot be cured. Last page is remedies for breach of sales. Did he sneeze?
Mm-hmm.
Last page, so you can turn off the timer. Oh my God. Remedies for breach of sales contract. The breaching party is entitled to damages. Difference between the contract price and the market value on the date of the breach plus incidental costs, or because land is unique, specific performance. Note that if the buyer wishes to proceed despite unmarketable title, they can usually get specific performance with an abatement of the purchase price. Liquidated damages. Sales contracts usually require the buyer to deposit earnest money with the seller and provide that. If the buyer defaults in performance, the seller may retain the money as liquidated damages. Courts routinely uphold the seller's retention of earnest money if the amount appears to be reasonable in light of the seller's anticipated actual damages. Real estate brokers. Real estate brokers are the seller's agents, but should disclose material information about the property if they have actual knowledge of it. Traditionally, agents earned their commissions when they produced a buyer who was ready, willing, and able to purchase the property. Therefore, the commission was owed regardless of whether the deal actually closed. The growing trend, however, is to award the commission only if the sale actually closes or if it fails to close because of the fault of the seller. And exclusive listing agreements. Under the exclusive listing agreement with a real estate broker, the broker's best efforts to sell the property is consideration for the broker's commission. Best efforts includes expenditure of time, effort, and money. If the property is sold by the seller or another agent during the listing period, the seller still may have to pay a commission. Exclusive agency agreements prohibit listing the property with other brokers during the time of the listing. Exclusive right to sell agreements additionally preclude the seller from selling the property themselves without paying commission.